Hi there, I'm Professor Blackmore, and I want to welcome you back to my channel and to another episode in my podcast series entitled The Hush Money Agreement That Just Won't Hush, wherein I will endeavor to break down all of the rigmarole surrounding the Donald Trump, Stormy Daniels side chick hush money criminal case in New York brought by Manhattan District Attorney Alvin Bragg. And I'm coming back to you today to analyze whether or not I think the Manhattan jury will convict former President of the United States, Donald Trump.
And as you know, I've come here from New York, where I'm being forced to endure a Biden show trial, all done by Biden, carried out by that's right, all being done by him, carried out by radical Democrat district attorney. You know who he is? Fat Alvin. What? Corrupt guy.
In addition, I will also endeavor to analyze what I'm hearing from a lot of so-called reputable attorneys on the TV for the past few weeks who have said over and over again that they don't know the identity of the other clandestine and hidden crime that Manhattan DA Alvin Bragg mentions in the indictment.
As a top scholar, great legal genius Alan Dershowitz stated, I've been doing this 60 years and I don't understand what crime he's being charged with.
And so, let's jump right in. And I want to start with the indictment, which states in count 1, quote, "The grand jury of the county of New York by this indictment accuses Trump of the crime of falsifying business records in the first degree in violation of Penal Law Section 175.10, committed as follows. Trump, in the county of New York and elsewhere, on or about February the 14th, 2017, with intent to defraud and intent to commit another crime, and aid and conceal the commission thereof, made and caused a false entry in the business records of an enterprise, to wit, an invoice from Michael Cohen dated February the 14th, 2017, marked as a record of the Trump revocable trust and kept and maintained by the Trump organization," end quote. And then you have counts 2 through 34, which relate to each $35,000 invoice that Michael Cohen submitted to Trump for repayment of the $130,000 that he paid to Stormy Daniels, of which transaction I outlined in great detail in part 1 of this episode series. Now, I want to go back to count 1, where it states that Brother Trump committed said acts, quote, with intent to defraud and intent to commit another crime, end quote. And so this is where I've been very disappointed with news coverage on this point of interest. And that is because we've seen one legal analyst after another state that we do not know what the other crime is. Some of these legal analysts have a law degree, but they've never tried one case in a court of law. And some of them don't even have law licenses. Now, it takes a special skill set to be a trial lawyer who has actually tried cases in a court of law. Some of these legal analysts are blinded by politics, and many of them are clearly blinded by groupthink. And I say this because several weeks ago in a pretrial hearing, Alvin Bragg told the judge that the other crime is New York Law 17-152, which states, quote, "Any two or more persons who conspire to promote or prevent the election of any person to a public office by unlawful means, and which conspiracy is acted on by one or more of the parties thereto, shall be guilty of a misdemeanor," end quote. Now, Alvin Bragg further informed the judge that he intended to establish that Trump violated New York Law 17-152 by proving that he committed one or more of the following three acts. Number one, that Trump, quote, intended to conspire with Brother Michael Cohen and editors of the National Enquirer to bury a story about an alleged one-night stand in 2006 with Sister Stormy Daniels by paying her $130,000, which was an allegedly illegally high campaign expenditure. Number two, that Brother Trump intended to violate state tax law when he disguised his repayment to Brother Cohen in the form of a series of monthly checks as legal fees. And number three, that Brother Trump intended to conspire to falsify the records of the National Enquirer through a plan to catch and kill stories that could hurt his 2016 campaign. End quote. Now, it is my understanding that Brother Alvin Bragg does not have to prove that Brother Trump actually did any of this. He only merely needs to prove that Brother Trump, quote unquote, intended to do one or more of these three things. So let me say that again, because this is the first reason why I think the likelihood is high that the jury can find Trump guilty if that is what they want to do. And that is because the jury does not need to find that Brother Trump intended to actually commit any one or more of these three acts. On the contrary, the jury only needs to find that Trump merely intended to commit one or more of the three acts. Now, I want to go back to New York Law 17-152 because it includes the second reason that I think the likelihood is high that the jury could convict Trump if that is what they want to do. And that is because New York Law 17-152 states, quote, any two or more persons who conspire to promote or prevent the election of any person to a public office, i.e. to any public office, state or federal, by unlawful means, and which conspiracy is acted upon by one or more of the parties thereto, shall be guilty of a misdemeanor. End quote. And so, Brother Trump only needs to be one person included in the conspiracy, but only one person in the conspiracy needs to act. In other words, the only thing that the prosecutor needs to do is to tie Trump to the conspiracy of the two or more people, but only one other person in the conspiracy needs to act. And that person who's doing the acting does not need to be Brother Donald Trump. It could be Michael Cohen. And that is why you see everything that the prosecution is doing is hung on Michael Cohen's testimony, because they're relying on him to be that one other person that's doing the acting in the conspiracy. And for that matter, it could also be Mr. Pecker. And that is why they were very, very, very thirsty to call him to testify first in the case. Now, in addition, this misdemeanor charge becomes a felony punishable by up to 4 years in prison if the records were falsified with the intent to commit or hide some other underlying crime, which are the 3 aforementioned crimes that I previously described to you. Furthermore, you hear a lot of legal analysts talking about federal campaign finance law when, as you can see by the information that I have just laid out, proving this case the way that Brother Alvin Bragg has set this scheme up has very little to do with having to actually prove anything having to do with federal campaign finance law. This is all predicated on violation of very weak New York laws, i.e. New York Law 17-152, that Brother Alvin Bragg and someone in Sleepy Joe Biden's Department of Justice smartly dug up. Now, in my prior episode of this podcast series, I have already outlined all of the reasons that I think all of this is absurd. There is no way that the judge should not have shut this all down the minute that Brother Alvin Bragg suggested it. And the top line reason that the judge should have shut this down is because none of this is outlined in the indictment. In addition, there are too many reasons why all of this should be overturned on appeal, but I think we can all see now that the only thing that Brother Bragg wanted to do was to get a conviction, whether it would be overturned on appeal or not. This is clearly done to be able to refer to Brother Trump as a convicted felon during the campaign season, and it is clear to me that the judge has been in on this dastardly litigation strategy since day one, and he is dedicated to seeing it to its completion. And so, I don't see why it would be hard to prove, because again, the way that this crime litigation scheme is set up, Bragg needs to prove count one, that Trump, quote, falsified business records in the first degree in violation of Penal Law Section 175.10 with the intent to defraud and intent to commit another crime, end quote. And again, the other crime is New York Law 17-152, which states, quote, any two or more persons who conspire to promote or prevent the election of any person to a public office by unlawful means, and which conspiracy is acted on by one or more parties thereto, shall be guilty of a misdemeanor, end quote. And as you can see, Brother Bragg does not need to prove any element of any federal campaign finance law to establish a violation of this crime litigation scheme, because the judge is allowing them to prove it by establishing, number one, that Trump, quote, intended to conspire with Brother Michael Cohen and editors of the National Enquirer to bury a story about an alleged one-night stand in 2006 with Sister Stormy Daniels by paying her $130,000, which was an illegally high campaign expenditure, end quote. Now, I honestly think that they were able to get enough testimony from Brother Pecker over there at the National Enquirer to establish this particular underlying crime, because again, all you need to establish is that Brother Trump merely intended to bury a story about an alleged one-night stand in 2006 with Stormy Daniels, not that he actually did bury the story. So, whether Brother Trump was actually involved in any actual carrying out of any part of the act is not dispositive based on the way that the judge is going to let all of this go down. In other words, Bragg does not need to prove that Trump actually did anything to bring about the happening of this violation. Now, Brother Bragg alleges further that number two, that Brother Trump, quote, intended, again that word intended, to violate state tax law when he disguised his repayment to Brother Cohen in the form of a series of monthly checks as legal fees, end quote. And keep in mind, again, the prosecution only needs to establish that Trump merely intended to violate state tax law, not that he actually did. Notwithstanding now, I actually don't think this was proved beyond a reasonable doubt, but again, it is my understanding that the judge will allow the jury to consider whether Brother Trump violated one or more of these three acts. So one juror could think Trump violated acts 1 and 3, another juror could think that Trump only violated act number 1, but the jury as a whole only needs to establish that Trump violated only one of the three acts. Now, in addition, Brother Bragg may also establish that Trump, number 3, quote, intended to conspire to falsify the records of the National Enquirer through a plan to catch and kill stories that could hurt his 2016 campaign, end quote. And so, I think Bragg can establish this as well. I think a lot of people are going through what I believe to be a non-dispositive analysis of whether non-disclosure agreements are legal or illegal, and whether catch and kill stories are legal or illegal, when the only thing that the jury needs to establish is, again, that Trump merely, quote, intended to conspire to falsify the records of the National Enquirer through a plan to catch and kill stories that could hurt his 2016 campaign, end quote. And again, I personally believe that Mr. Pecker from the National Enquirer provided evidence in the form of testimony that this occurred, whether it is illegal or not. There are some that believe that if there was another reason for Trump wanting to do this, i.e., to ensure that his wife Melania did not find out, then that would be enough to prevent the jury from finding that Trump is guilty of committing this act. But I believe this analysis by some is based on a non-dispositive application of federal campaign finance law that will not be a factor in the jury instructions in this case. I believe the judge is going to allow the jury to base their finding on a black letter reading of this violation, and the only thing that they will need to establish is whether there is evidence that Trump was involved in catching and killing stories that could hurt his campaign. Again, New York law 17-152 states, quote, any two or more persons who conspire to promote or prevent the election of any person to a public office by unlawful means, and which conspiracy is acted on by one or more of the parties thereto, shall be guilty, end quote. And so again, the only thing that the prosecution needs to do is to tie Brother Trump to the conspiracy. And because only one other person in the conspiracy needs to act, Brother Bragg does not need to establish that that one person is Brother Donald Trump. It could be Michael Corn or it could be Mr. Pecker. And so, ladies and gentlemen of this internet courthouse jury, what do you think? I mean, based on my analysis of what I can see Brother Alvin Bragg is trying to do you think the Manhattan jury will find Brother Trump guilty, or do you think they will see through this illegal crime litigation strategy that Brother Bragg has devised, and that they will come back hung, meaning they could not reach a unanimous verdict, or that they will outright acquit Brother Donald Trump of these baseless charges that the judge should have thrown out on day one? Or do you think that they will find Brother Trump guilty? Please let me know what you think by leaving your comments in the comment section below. And I want to also ask that you please give me a big thumbs up. And I hope you'll also consider donating to this video and my entire channel ministry by donating to the Professor Blackmore Cash App. And I want to also ask that you please help me out by subscribing to my YouTube channel and set your notifications. And then after you set your notifications, turn on your notifications so that you'll be notified whenever I come back with more hot tea from the church house, the courthouse, the White House, and everywhere else, honey child. And please also follow me on TikTok and Instagram.